More on this debate and on the ins and outs of the U.S. Constitution, I'm joined by Janet Johnson. She's in Jacksonville, Florida, and she is a criminal defense attorney and legal commentator. Janet, for our audience that may not be familiar with the U.S. Supreme Court and how it works, the two attorneys can come in there and argue their case, but they're almost immediately interrupted by the justices and peppered with questions. And that's where analysts like you have a tendency to kind of hone in on what they're asking and stuff. Was there anything that you heard today from the questions by the judges that might indicate which direction they might go on this?
Yeah, and it's the Socratic method. We're all in law school. That's pretty much how we're taught. We give an answer and we're interrupted all the time. And right off the bat, when the people who are challenging the proponents of the Proposition 8, which has been struck down in California, they're the ones bringing this case. And they started in with a very flowery opening, and immediately they were shot down by the justices saying, wait a minute, before you even get to the merits of the case, can you even bring this appeal? And that's an issue that I think might be a stumbling block right out of the blocks, because they're basically saying, as straight people, as people who want marriage to be opposite sex, we're challenging the Supreme Court of California, which struck this down. Usually it would be the governor or the attorney general who brings the appeal to the Supreme Court. In this case, both the governor and the attorney general of California said, we don't want to do that. So a group of private citizens are doing it, and the justices spent a lot of time questioning them, saying, can any private citizen come to the Supreme Court and challenge a ruling? And that's something that I think they're going to have a hard time overcoming, and the justices might never even get to the merits of the case, and they might say, we're kicking you guys out because you don't even have standing to come to the Supreme Court.
And what would that mean for people who aren't familiar? What does that stand? Where do things stand then?
Well, what that means is that the justices kind of take an easy out, and they say, we're not going to really decide gay marriage in California because we don't even think these parties have a right to be here. So they're basically kicking the people off the playing field before they even score, and just saying, we're not going to have this game. We're not even going to hear the argument. And they spend about half of the time having that discussion to say, well, I don't know if you people can even argue this in front of us. And then at one point, Justice Roberts, the chief judge, came in and said, okay, let's get to the merits of the case. So then when they started arguing the merits of the case, they kind of did a role reversal, and it appeared that there's a split. Most of the justices said, I think that getting married is a fundamental right, and if you're saying that procreation is the point of marriage, are you saying that people over 55 shouldn't be allowed to get married? Are you saying that if people don't have children, they can't get married? That isn't today how we define marriage in America, and I think the justices had a hard time with that issue. And they also then brought up interracial marriage, which used to be illegal in this country too. I think the Loving case, which basically said that people of mixed races can get married in spite of state laws, that may be a precedent that they have a hard time overcoming in trying to basically say opposite sex marriage should be the law of the land.
Yes, Charles Cooper seemed like he was on the defensive quite a bit with some of the questions you just alluded to. There is also the Defense of Marriage Act, which is another case that comes before the court. Is this a case? They probably can't kick this one, can they? Can they spike that one?
Well, no, that's correct. That's true. That's tomorrow, and that's basically about the federal law that said that marriage should be defined, and this is a law that was signed by President Clinton, surprisingly, that said marriage should be defined as a man and a woman. And that's based on a woman who came to court because her partner of many years, some 30 years, who was a doctor, passed away, and she was left with a six-figure tax bill that nobody is even contesting she would not have had if she was of an opposite sex. So if my husband dies, I don't have to pay taxes because I've inherited it. There's no estate tax on that. This woman was left with a really huge bill, and so she challenged it and said, because federal law defines marriage as opposite sex, I'm being treated unequally. And the U.S. Constitution, the 14th Amendment, doesn't allow that. It says that I should be treated the same as anybody else under the law.
Janet Johnson, live for us in Jacksonville. Thanks so much for your insights. Really appreciate it.